The Irish Republican Army, or IRA, was a separatist terrorist group which killed hundreds of innocent civilians in the United Kingdom from the 1960s until the 1990s. In 1988, the Home Secretary in the United Kingdom issued a rule to the British Broadcasting Corporation, the BBC, and the Independent Broadcasting Authority, the IBA, directing that they must not broadcast on television or radio any words spoken by representatives of the IRA or its political wing, Sinn Féin. They were allowed to have a newsreader read such words, and they could even have an actor do so, but they could not broadcast the words directly from the mouth of an IRA representative. The two broadcasters challenged this directive on the basis that it infringed Article 10 of the European Convention on Human Rights, which included the right to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. Article 10 includes an exception allowing governments to limit information for national security, but the question before the court was whether the Home Secretary's decision and the legislation which empowered that decision should be read as being subject to Article 10 of the Convention. The court acknowledged the principle that if a statute is ambiguous, then it will generally be interpreted in a way that is consistent with the nation's international obligations. But this is not a general invitation to impose international law on domestic statutes. The court said, where Parliament has conferred on the executive an administrative discretion without indicating the precise limits within which it must be exercised, to presume that it must be exercised within convention limits would be to go far beyond the resolution of an ambiguity. It would be to impute to Parliament an intention not only that the executive should exercise the discretion in conformity with the convention, but also that the domestic courts should enforce that conformity by the importation into domestic administrative law of the text of the convention and the jurisprudence of the European Court of Human Rights in the interpretation and application of it. The courts would not allow this to happen. This case confirms that international law is subordinate to national law. International law has virtually no power in relation to national law unless the Parliament chooses to adopt the international law. This includes grand but ultimately pointless statements about rights.